The first objection goes to the document attached to the defendant's response as Exhibit 3 to Exhibit E. And I wanted to note for the record, I noticed this morning the objections say Exhibit 3 to Exhibit A. That's a typo. It should say Exhibit 3 to Exhibit E. That document is what's been called by the defendants an audit performed by Denise Thordson. If you recall, Your Honor, that document was attached to the defendant's expert designation of Ms. Thordson, which Shift Key moved to exclude, and the court granted the motion. Sorry. Go ahead. And the court granted that motion to exclude. Denise Thordson has been ruled by the court not qualified to provide expert opinions or testimony in this case. And that includes the report that she prepared as part of her designation. That's a document that, despite that previous order, the defendants have attached again to Denise Thordson's declaration in support of their response to the motion for summary judgment. We would ask that the court strike that document for that reason. And secondarily, even if the court hadn't struck Ms. Thordson as an expert, the document is hearsay.
Response?
Your Honor, as a preliminary matter, defendants ask that the court consider plaintiff's objections and motions to strike as untimely. Local Rule 2.09 states in pertinent part that for reply briefs in support of a motion for summary judgment must be filed and served no less than 3 days before the hearing. Briefs not filed and served in accordance with this paragraph likely will not be considered. It's our position that plaintiff filed this reply at 3:46 p.m. yesterday afternoon, which is less than 24 hours before this hearing. But notwithstanding the untimeliness of plaintiff's reply, plaintiff seeks to strike defendant's summary judgment evidence because it provides expert testimony of Ms. Thordson. This stance now taken by plaintiff is contradictory to its prior representations to the court, where plaintiff sought to strike Ms. Thordson as expert. In pertinent part, plaintiff stated in its motion to exclude the expert witness, Ms. Thordson, that the bulk of her testimony appears to be consistent of simple math, adding up the amounts of contested invoices. No specialized knowledge is required to perform these basic calculations, and defendants have not indicated any specialized training or expertise that is required to calculate the amount of the contested invoices that is a part of the audit.
Ma'am, first of all, this is not a reply brief. It's just an objection to evidence. And in fairness, I think to Shift Key, we received about a 2,000-page response 7 days before the hearing. We've been diligently working through that, preparing those objections. And yes, we did file those yesterday. With respect to the motion to exclude, the opposing counsel references, certainly the mathematical part of that was part of the motion to exclude, but it wasn't the only part. More importantly is that what Ms. Thordson attempted to do and continues to attempt to do is interpret the agreements at issue to tell the court in this audit report that she has determined, based upon her investigation, she says, that certain shifts were not properly authorized or were not worked, or any number of reasons that justify the defendant's refusal to pay for those shifts. That was also part of the motion to exclude, and the court granted the motion.
I mean, typically on objections like this, especially given this, I'm not going to be super strict on the timeline that the local rules would give the judge a little wiggle room. You know, I'm not going to strike the exhibit as a whole. I do think there's some things in there that are probably useful, but let's get on to the merits.
Okay, thank you. Well, we had a few more objections just to statements in the declaration.
I will tell you, you only have 30 minutes. So
okay.
What I'm going to do, I'm going to give you 15 minutes. Start keeping time. You can use it however you like. If you want to spend much time.
Okay. Can I ask the court to consider those objections and rule we've provided a proposed order. Would the court go ahead and rule on that either at the end of this hearing or afterwards, and we can bypass the argument? I handed it to you, Your Honor, in the binder, in the front copy.
Okay, that's part of the checklist order?
There were two. One is a checklist order for the MSJ. One is a checklist order for the objections.
Okay.
Thank you. Moving to the merits of the motion. First and foremost, Your Honor, the motion, well, it's a traditional and a no evidence motion on the defendant's counterclaims. It doesn't relate to the plaintiff's affirmative claims. It doesn't relate to the defendant's defenses. It only relates to the counterclaims. I understand the burden is high on a motion for summary judgment. I get that. And certainly the defendants have raised defenses that we haven't moved on, but the counterclaims specifically, we believe were just the last ditch effort to try to leverage a settlement, put some exposure or potential exposure on the plaintiffs, and try to get this thing resolved. There are 7 counterclaims. We filed for traditional and no evidence summary judgment on all 7 of those. And the biggest issue here is evidence of damages, and this relates to every single counterclaim. And that goes, first of all, to that audit, Your Honor. If the audit, which sets forth Denise Thornton's expert testimony on her calculation of what she believes to be their damages, if that is not admissible, and it's already been excluded, there is no evidence of damages on any claim. Not to mention the fact that even if it is admissible, after Denise Thornton prepared that supposed audit, she testified several times during her deposition that the defendants do not know and cannot determine whether the shifts that are included in her audit report were or were not worked. She just doesn't know. That means the defendants don't know. She was their corporate representative. And that's important because that raises a speculation issue. There is a surmise, there is a suspicion by the defendants that some of these shifts may not have been worked. And Denise Thornton has assigned a dollar figure in the hundreds of thousands of dollars to her surmise, but it is not evidence. There is no evidence of damages for any of the defendants' counterclaims. Moving on to the specific counterclaims. I'll start, Your Honor, with the equitable estoppel counterclaim. The Dallas Court of Appeals has held as recently as 2021 equitable estoppel, and this is a quote from the City of Dallas v. PDT Holdings case. The quote from the court is, "Equitable estoppel is not an independent cause of action. It's a defense. If the defendants want to raise that as a defense, they had an opportunity to do so. It is not a separate claim, and it can't justify a counterclaim." I don't think the defendants dispute that. At least they haven't mentioned it in their response. So we would ask the court to, in addition to the no evidence of damages, to go ahead and dismiss that one on legal grounds. Moving to the breach of warranty claim by the defendants. This raises a distinction in the case law in Texas between breach of warranty and breach of contract. And I'm sure you see it all the time. But case law tells us that when a party fails to deliver as promised, a breach of contract, not breach of warranty, occurs. Conversely, Your Honor, when a seller delivers non-conforming goods, that's when you get a breach of warranty. That's what the case law tells us. Really, it's more of a UCC issue. It comes up in the sale of goods all the time. Sometimes you can have an express warranty in an agreement for services. That's not the issue here. And again, we see in the defendant's response to our motion for summary judgment, they cite case law related to those warranties for goods, not services. And then if we look at the counterclaim itself and the facts that have been alleged to support the defendant's breach of warranty counterclaim, those facts are the same as the facts the defendants have alleged in the breach of contract counterclaim.
I have not seen breach of warranty raised in a contract. What is your response to the breach of warranty claim? Like, does it apply to services?
Your Honor, one second. Your Honor, under our analysis that put forth in our response, we contend that it does apply to the services and the goods provided.
Go ahead.
And Your Honor, that is expressly set forth in the contract in 4.0 Shift Key's responsibilities, that Shift Key guarantees and warrants that all nursing professionals registered on its website and available within Shift Key have been advised fully.
I'm not saying there may not be a breach of contract, but what case law do you have to say that the warranty claim can be applied to services?
Your Honor, at this time, I'm not sure if we put forth that specific case law in our briefing.
Okay. I'm gonna go ahead and grant the breach of warranty count. All right, what else do we have?
We have a motion as to the declaratory judgment counterclaim. This again relies on pretty well-established case law, especially in Dallas, in the Dallas Court of Appeals, that declaratory judgment actions are not available to settle disputes already before the court. Instead, the purpose of the DEC action is to establish what the courts call existing rights between the parties. We're past that at this point. There's a breach. There's a competing claim for a breach from the other side. That's what we're looking at in the case. The DEC action is inappropriate as a matter of law.
So you guys don't have a DEC action?
We do not. It was raised as a counterclaim by the defendants.
How I guess I don't really see how the declaratory judgment apply here.
Your Honor, it was our position that under the case law, defensive declaratory judgment may at times present issues beyond those raised by the plaintiff. And under the client service agreement provision 3.3, we would like clarification to that provision for moving forward. As the case law says, when a declaratory judgment counterclaim has greater ramifications than the original suit, the court may allow the counterclaim. It's our position that we put forward testimony from Ms. Thorson saying that Shift Key is a major player within the St. Louis area for securing staffing individuals at the facilities, and clarification to this provision would provide greater ramifications than those sought by.
I'm gonna grant the summary judgment on the declaratory judgment. Okay, do you have anything else?
What we do, we have a few more claims. I'll try to tick through these, Your Honor. The next one on my list is fraudulent inducement and fraud. We argue there's no evidence of any element to that, but I think the strongest points that we make in our motion are the elements of reliance and, again, damages. As opposing counsel just mentioned to you, she raised this issue that Shift Key is a big player in the local market where these facilities were located, and that goes to testimony from Ms. Thorson during her deposition that she had prior experience with Shift Key from working at a previous company. She reached out to Shift Key about providing services. She'd worked with them in the past, and she picked them, she said, because they were able to provide staffing.
All the briefing, isn't there pretty extensive? Sorry, isn't there pretty extensive evidence that there were a number of statements made about what was going to be done in terms of screening and making sure that before billing was submitted, that it wasn't that it was signed off on by the other side, and there's allegations that wasn't done. I mean, wouldn't that be kind of a classic, if that's true, isn't that kind of a classic negligent misrepresentation and fraud claim?
Well, those are provisions that are stated expressly in the contract. They're superseded by the provisions of the contract. I understand that the defendants argue that there were statements made prior to the contract, but the parties then put pen to paper, drafted the contract, and set forth specifically the rights and obligations, including the approval process. Shift Key does not dispute that timesheets were required to be approved. The dispute is whether the parties properly complied with the approval process set forth in the contract. So it isn't a fraud claim, and it isn't even fraudulent inducement in my mind, because They sat down and they wrote the contract and spelled out specifically what the obligations would be. It goes back to, did the parties perform under the contract? That's the real issue here. I think that's the only real issue they can potentially raise. And there's no evidence of reliance. If they say that there were representations made prior to the contract, where is the reliance on that? The fact that they entered into the contract isn't enough. And the only evidence they've offered is testimony from Denise Thorson, in which she declares in her declaration, I relied on that, or the defendants relied on that representation. That's conclusory. That cannot be readily controverted, Your Honor. That would require us to get into the defendant's mind, which case law says it cannot readily be controverted and it's inadmissible. Without that, there's no evidence of reliance. Secondarily, going back to the admissibility of the audit report, there's no evidence, assuming that the court agrees with us on the motion to exclude for the various grounds raised, there's no evidence of damages on the fraud or fraudulent inducement. And on fraudulent inducement, I'd also point out there's a heightened reliance requirement for fraudulent inducement that the defendants have. There's no evidence of that.
Response on that?
Your Honor, it's Denise Thorson's testimony that but for the representations made by Schiffke, in particular, its representative, Mr. Wicker, she would not have entered into these agreements. We've highlighted numerous excerpts from her deposition testimony, as well as Mr. Wicker's, that goes to this point of fraudulent misrepresentations and omissions. If the court would prefer, I can give some examples or rely on our briefing.
I'm going to go ahead and deny the summary judgment on the fraud and the negligent misrepresentation. So right now we're dealing with, I'm denying on the breach of contract too. So I'm really just dealing with the DTPA counterclaims and the equitable estoppel. What is your response on equitable estoppel? Is it a cause of action? I don't know that it is.
Your Honor, it was our position in our briefing that it was a cause of action and not just a defensive theme.
What? Okay, you got to give me a little more than that. What's your basis? What's the case law?
We cited, Your Honor, to a Texas Supreme Court case providing the elements under Allied Pilots Association. That's on page 71 of our response, as well as another Texas Supreme Court case, Johnson v. Higgins of Texas on page 71.
And those indicate that that's a cause of action.
It indicates that estoppel prevents one party from misleading another to the detriment of that party's. And we argue that we satisfy the elements outlined in those two Texas Supreme Court cases.
How do you respond to that?
I respond with City of Dallas v. PDT Holdings from the Dallas Court of Appeals, in which the court holds, and I quote, equitable estoppel is not an independent cause of action. It's a defense.
Okay, I'm going to go ahead and grant the summary judgment on equitable estoppel. So let's go to DTPA.
Thank you. The DTPA claim, Judge, you've already granted as to breach of warranty. The DTPA claim relies heavily on certain representations and warranties that the defendants allege.
But that's not the only thing they're alleging, right?
It's not the only one. There are a few. There are 7 general categories of representations or omissions that the defendants rely on to support their DTPA claim. One is they argue shift key induced them to execute the agreements based on the representation that shift key would provide discounted rates to the facilities. Just first of all, I don't think it's intentional, but the defendants they seem to misunderstand the difference in rates that shift key offers to the facilities and rates that shift key permits to the nurses who are taking those the open shits. Second, though, Your Honor, there's no evidence that the shift key did not provide discounted rates. Keith Wicker testified.
So let me ask this. I guess my big question for the DTPA is, I know there's certain, your time is up, but I've kind of, there's certain transactions that are excluded in the DTPA. I didn't see anywhere that you argued that this was a transaction that would not be covered by the DTPA. You agree that this is the type of transaction that would be covered by the DTPA, correct?
Yes, Your Honor.
Okay. With that, I'm going to go ahead and deny the DTPA counterclaim summary judgment. All right. I think we ruled on everything at this point. All right, great. So just to summarize, I've denied the summary judgment on DTPA. I've denied it on fraud and negligent misrepresentation. I've granted it on equitable estoppel. I've granted it on breach of warranty. I've denied it on breach of contract, and granted it on a declaratory judgment. Anything else we need to chat about today?
I would just ask if the court would enter, whichever way you rule on the objection to motion to strike.
Okay. Anything else, guys? Have you guys mediated this case yet?
We have.
Okay. When are y'all set for trial?
Is it April?
April. Okay. Great. Anything else, guys?
Nothing from Shifkey.
Nothing further, Your Honor.
All right. You should be able to get these orders online by next week.
Thank you.
Thank you.
And I will say the briefing was a little long, so some judges would probably be a little upset by how long it was, but it was very well done on both sides. I thought both sides did a really good job of briefing this, and I would encourage you, we're state court judges, we're not federal judges, we don't have law clerks, so maybe shorten them a little bit. Most people combine not always, but usually the traditional and no evidence. There's just a ton of briefing to go over. And so, but it was very well done. If you could just make it a little more condensed next time. All right, guys, you have a great rest of your day.
Thank
Thank
you.
you, Your Honor.